We'll go on the record in State versus Shields, CR 2021-412 and CR 2022-74. Sir, you're Mr. Ryan Shields?
Yes.
I'll note that Mr. Ryan Shields is present. He's represented by Mr. Standiford, and Mr. Seuss, Chief Deputy, is here from the County Attorney's Office. We're here for a pretrial conference on the trial that's currently set on November 10th. I'll note as of right now I have 4 cases set that date, and Mr. Shields is 4th in line based on his out of custody status. He's 3rd in line based on his arraignment dates. I've been provided with a petition to revoke release conditions that is signed by Mr. Seuss today. And Mr. Seuss, this has not been filed at the front counter. You're providing it to the court right now?
That's correct.
Okay.
It's prepared at the full court.
And Mr. Standiford, have you received a copy of this motion?
I did receive it this morning, Judge.
Okay. And have you been able to provide your client with a copy of the motion?
No.
Okay. Are you in a position where you can make an argument on behalf of your client on this motion? It seems that you've sort of fallen in between. Mr. Seuss is alleging that you're potentially a victim in a new matter, and also representing your client in this matter.
Well, Judge, I did not know a lot of what happened until I saw the motion today. I do need to make the court aware that my client stayed in contact with me. We spoke last week for about 45 minutes. Does not miss his hearings, but I do have to ask the court to allow me to withdraw based on the circumstances.
Mr. Seuss, there's a Facebook post attached, and it doesn't appear to have a date. It indicates potentially, I don't know at the top if it says 5D next to the little world. Do you believe that was from 5 days ago, or can you give me an indication as to what the date
I'm
of that
not too
post?
familiar with social media sites, but I think if the court to determine by the content in that post that it was done recently. He was talking about his upcoming trial. So it definitely was done recently. And Judge, also the court should be aware that there are additional posts that in the interest of time I did not attach or refer to, but those posts, while not being physically threatening, were certainly intimidating, were directed toward both Ms. Bystricki and also to the victim in this matter.
Okay.
And Judge, just so the court's aware, we did have interviews scheduled a week from this Wednesday. We would not be prepared for either case on the November date. I was going to ask for a setting on both cases sometime after the first of the year.
First thing I'm going to do is I'm going to grant Mr. Standiford's request to withdraw in the matter. I'm going to appoint Mr. Collins, one of our other counsel, who is here. I think it would be appropriate to allow Mr. Collins to at least speak briefly with his client, his new client, before I address the motion. So I think what I'm going to do then is take a recess for approximately 15 minutes. Mr. Collins, you can. Mr. Standiford, do you have the file with you today you can provide to him? Okay. And then, Madam Clerk, probably do I need to ask that this go to the front desk, or can you file it in this case? I'll ask you to file that in. So we're going to take a 15-minute recess. It's time for that anyways. Mark, can you get one of Mr. Collins' business cards for Mr. Shields? Mr. Shields, I'm going to order that you remain in the courtroom and not leave the courtroom until I recall your matter. Do you understand that, sir?
Yes, sir.
Okay.
Your Honor, may I have a copy of the filing? I gave you my copy. I just need a
Yes.
file.
Mark, if you can, maybe Mark can make a copy of that. And so, Mr. Standiford, that was your last matter of the morning. So when we come back, you'll be no longer with us. Mr. Collins will take up that matter, and then I have several Warshaw and DeBridgeton matters that I'm going to be doing before we jump full scale into your calendar. Okay, we'll stand at recess. I'll see everyone back at 10:15.
All right.
Here's the original for you.
That one doesn't have it. I don't think it has battery in it. No. It doesn't work. So. No. No. Because it didn't turn on. And then on the-
I'll note. Okay. Okay.
I wasn't my part. Now I'm ready.
Okay. We'll return to the Shields Matters CR 2021-412 and 2022. Chief Deputy is still here. Mr. Collins, have you had a chance to review the petition to revoke with your clients?
Yes, I have, Your Honor.
Okay. In counsel, I'm looking at Rule 7.5. If a petition such as this is filed, it appears the court can either issue a summons, a warrant, or notice a hearing. And it seems to the court that the rule contemplates, and under subsection D, that there would then be a hearing. Mr. Seuss, is it your position that the defendant should be taken into custody today? Is that correct?
Yes, that the rule does contemplate an ex parte petition by the prosecutor.
Okay. And what would be the he's here, so the warrant isn't because he's not likely to appear. What would be the purpose of the warrant then today?
Well, two reasons. One, he's violated his conditions of release by committing a new offense, and two, he's proven that he's a danger not only to the victim, who was obviously a witness in the case, but also one of the deputy county attorneys and the defense counsel himself.
Okay.
And Judge, I've gotten more information regarding the defendant's activities and down in Phoenix and threatening witnesses in prior cases, and we're looking into that as well. But I suspect we're going to have a lot of information for the court at the hearing, at the evidentiary hearing. Of course, the defendant is entitled to hearing, but the state does have the right to secure that warrant up front, which is why the rule requires a verified petition by the prosecutor. And if the rule didn't contemplate that the defendant could be taken into custody or warrant issued immediately, then the underlying purpose of the rule would eliminate any emergency or exigency, which is the whole reason for filing the petition, to secure the defendant's release. But yeah, he's here. I'm not arguing that he's not going to appear in court, but that's not the issue of the petition.
And there, as of right now, you've presented facts that he has committed a new offense, but am I correct that he has not formally been charged with a new offense?
No, it just came to my attention, so I don't know that that's relevant, that he hasn't been formally charged, so long as there are facts to support the petition.
Mr. Collins, I'll hear from you.
Your Honor, first of all, my client denies that this is him. He has threats from his ex-wife, that she would have him thrown in jail. He hasn't been able to have access to his Facebook account for a number of weeks. If I am to proceed on this, I would need funds to employ a forensic computer expert to determine where the information came from, whether or not somebody's hacked his account. IP addresses are usually attached to posts, so we can find out where those locations are. It can be tracked down. And second of all, Your Honor, I'm not sure it's a. I keep reading this, trying to figure out where the threats are. Obviously, he's unhappy with his attorney and much of the proceedings of the case, but I'm not seeing a threat. Obviously, not being happy and exercising your First Amendment's rights is not a crime, nor is it a basis to revoke somebody's release conditions. So I'd ask the court to deny it. If the court wants to proceed on it, then I'd ask the court to let him remain out. I believe that the warrant provisions of the statute is to secure appearance, so that it can be heard, so that I can present evidence. He has face screenshots of him trying to recover his password for his Facebook account back many months, so he's had issues with those in the past, Your Honor. So I would need opportunity to present that evidence. He's appeared at all of his hearings. If there are new offenses which they believe they can get indictments on, nothing I can do about those. But Your Honor, as it relates to this motion, it should either be denied or set for hearing so that I could address the factual information of the Facebook post itself.
If I were to set a hearing this Friday at 4 o'clock, Mr. Seuss, do you have someone in your office that you could have available to cover that hearing either
We'll get
yourself?
someone to cover it, and Judge, just so there's no doubt from the court's perspective that this is his site, although he attempts to disguise himself by beginning his last name with a C instead of an S on the post. You can clearly see that there's a picture of him on the phone. This is him.
Mr. Collins, are you available this Friday at 4?
I am, Your Honor.
Okay. I am going to order that a warrant for the defendant's arrest be issued. I'll order setting a $25,000 secured appearance bond. I'm going to set in each matter. I'm going to then set a hearing this coming Friday. Secured appearance bond. I'm going to set in each matter. I'm going to then set a hearing this coming Friday at 4 o'clock. Judge, if I'm still in trial on the Hutchins matter, Judge Wolak is scheduled to cover my calendar, so he would cover it at that point. The court finds that the attachment is both, I'm not prejudging its ultimate authenticity, but it seems to put forward an appropriate amount of information that the defendant would be aware of. The court also finds that if true, there is a direct threat at least several times to Mr. Standiford in there, reference to physical violence following a verdict, reference to bringing a mouth guard to prevent or minimize that physical violence. Now, so I've done that. Mr. Collins, this matter was set for trial. Well, one of them was set for trial on the.
Your Honor, can I see clarification of the bond?
Yeah.
You said 25,000. Is that in each case, or is that there are two case numbers on the motion?
Mr. Seuss, you've asked for each.
Yes.
I'm going to go ahead. I'm going to do 12,500 in each for a total of 25,000 secured. I realize that's different from what Mr. Seuss is asking for, but the court believes that's appropriate.
It's ACIC or NCIC.
And ACIC?
And I won't be able to get that done.
So, Your Honor, the next question I have as it relates to the warrant, we do see many law enforcement officers in the room.
Yes.
If they take him into custody on that warrant, I don't know if the court just wants to order him into custody and he can secure bond, or if the court is giving him time to secure bond.
Well, it's my intention that he go into custody today. So
right.
if the parties have no objection, I'll just order that pending that hearing, his release be revoked. That'll save the clerk from issuing a warrant, and then he'll be taken in.
Well, I want him to have an opportunity to post bond if
Right.
he's able to do that. So,
I'm going to order that he be taken into custody, and then he can make provisions for bond if he chooses to.
okay.
So, Madam Clerk, what I will do is I'll order that pending the hearing, his release will be revoked, that he'll have 12,500 bond on each. That will save you issuing a warrant. That will save everyone clearing the warrants. Okay.
So I would just assume that the law enforcement would execute that warrant.
Right, and then it's probably, you're correct, Mr. Collins, I think that's gonna save us some paperwork. So, Mr. Collins, you're brand new on the case. I don't know if you were here when I said his case was fourth on priority. I think he would now be third, given the fact that he's gonna be in custody. What I'm inclined to do is vacate the trial date and set a trial setting status or case management in about 3 weeks in each of these on the 28th of next month in Globe.
That's
actually
fine.
okay.
Yes.
So, Madam Clerk, I'll vacate the November 10th trial.
I can't make that up.
I'm actually going to set it for a case management conference on both on November 14th at
Time?
11:30.
I'm sorry,
11:30 in Globe. Okay.
So it's court and evidentiary hearing, the 1 hour hearing?
Yes. Okay. And I'm not going to use this order since it's in the since I put it on the record. So I'm not going to use that.
Okay, yes, that's better.
Okay. Okay.
Okay, can we have recess for a moment?
Mr. Seuss, anything further on Shields?
Oh, thank you.
Mr. Collins, anything else on the record?
Nothing on the record.
Okay, and then do we have someone in that room? Can we have whoever's in that room step into the hallway and have Mr. Collins have a conversation with his client in there? So, Mr. Collins, if you'd like to move in there with your client, we'll take up some of Mr. Warshaw's matters.
Okay. Let's go in the conference room here so we can chat a little bit more, okay?
Okay. Actually, I think we just have one with Mr. DeBruy. Well,
I don't know that if they're ordering into custody, I'm not sure they'll let you talk to her, but I can relay a message to her.
Yes.
So let's step in here and talk, okay? So the court can move to its next case.
okay. Mr. DeBrigida, can you hear us?
No.
But don't leave until we talk, okay?
Mr. DeBrigida, can you hear us?
Let's step into the conference room real quick.
Oh, he's in the waiting room. Okay, we'll wait just a moment.
Yes, ma'am. That's not my,
It's up to the jail staff, ma'am, and if I believe their process is that once he's into custody, they will not allow physical contact with anyone.
let's step into this conference room, all right? You okay?
Just pay attention for just a second. in case anything happens. I don't think it's going to, but I'll let you know.
Come on, man. I got you. It's gonna work out.
Don't say just didn't like something crazy happen and you have your head down.
Yep.
Yes.
Cash issue.
Is that enough? We're doing it right now. Let Mr. Richard.
Good morning, Your Honor.
Good morning. We'll take, as soon as the clerk is finishing up my paperwork from my last matter.
So the hearing is Friday, which is what day?
The 21st.
21st. Okay, so then
And Judge, while we're waiting, I see that there's an arraignment for Ms. Braswell. I don't think I have an indictment yet, so
Okay.
might have